state voice to your chief judge.
Good morning and welcome to a session of oral arguments before the 5th District Court of Appeal. First, I'd like to introduce the panel. On my right is Judge Emerson Thompson, and on my left is Judge Richard Orfinger. We have 3 cases on the agenda this morning.
The middle one was canceled.
The middle one is canceled. That leaves us 3, I believe.
No, 2. BAXLEY and Karamafouche.
Well, but there's also another case on there. I don't think it's been
That's an OAW
expedited. All right. The first case is William BAXLEY versus State of Florida.
May it please the Court. My name is Robert Harper from
Sir,
California.
before you begin, let me ask you how much time, if any, do you want to reserve?
May I reserve the last 5 minutes, Your Honor?
You may reserve 5 minutes, and I've got it down here.
Thank you, sir.
You may proceed, sir.
My name is Robert Harper from Tallahassee. With me at council table is my law partner, Robert Augustus Harper III. If you please, our position today is that the trial in this case was flawed by the admission of the blood alcohol test, and that it did not satisfy the mandate of the Supreme Court President and McBride, Townsend, and most importantly Miles, which are a trilogy of cases decided approximately the same time. In Miles, the Supreme Court said that compliance with the statutory mandate for reliable procedures and administrative rules is essential. In this trial, we are complaining in part that the trial judge failed in his obligation to be the gatekeeper, if you will, by making no findings of fact, no conclusions of law as to the reliability of the test. In fact, the parties stipulated that the testing procedure was such that it would not trigger the strict liability, automatic presumption of intoxication, part of the statute. And we argue that because of that stipulation, if it's flawed in that respect, then we are back to the common law approach that the Supreme Court set out with a 3-part test in Bender.
Could you highlight for us specifically, I agree with you that we're back to the 3-part test, so now tell me your specific concerns about how this blood was handled and presented, not in general the concerns, but the specific to this case.
Your Honor, we briefed that there was not any evidence that the vial was inverted according to the rules which have been readopted in their present form this year. They're supposed to be inverted and shaken so the coagulant.
But again, if they're not trying to get it in under the presumption established in the rules and the statute, don't we then go into the common law theory?
Yes.
And they have to show that it wasn't tampered with and, you know, the usual stuff. And
Yes.
so even if we accept the testimony that it wasn't inverted, I mean, I'm trying to show, you know, where do we establish some unreliability based on, as I understand it, the examiner up at FDLE said there was no evidence of clotting that she saw. And there was mixed testimony, I think, about whether a lack of preservative would cause the alcohol content to go up or down. I guess it kind of was all over the place.
The First District has addressed that point in Leverett v. State, which is interestingly cited in the State's brief. It is 942 Southern 2nd 42, by saying, but it cannot be assumed the jury weighed the evidence and found the actual impairment so the conviction could be obtained under the case when it's tried in this manner. There's a Miles violation in the First District. And what I'm saying is that we are trusting the jury, in this case, to make the findings of fact of reliability instead of the judge being the gatekeeper. And the jury is not instructed nor trained. And there was other thing most important in Leverett was there were, just like here, severely disputed evidence as to the testing and the handling of the vial samples and what would be the results.
Counsel, let me take you back to the question that Judge Orfinger asked about what your concerns are and as to how this blood was handled. And you mentioned the fact that there was no showing that it was inverted, and apparently this is one of the procedures you're supposed to follow by inverting the vial to make sure it's mixed properly and everything. My recollection, and correct me if I'm wrong, was that there just wasn't any testimony that it was inverted. There wasn't any testimony one way or the other. Is that accurate?
Well, there was testimony. One officer said they
didn't see any inversion of it when it was put into the little kit that they put it into.
But we submit that's the state's obligation to put that kind of evidence on. There's 7 rules of procedure.
Well, I guess that's my question. And your argument is that the state has this obligation to show that it was inverted?
Yes, sir. And I don't think it's my argument. I think that's pretty clear what the Supreme Court has said, that to allow this evidence to be admissible as a matter of law, there is a scientific reliability which is the state's obligation to establish.
Does the record reflect whether that argument was made to the jury in this case or the judge that there's no evidence that it was inverted and it should have been?
Yes, sir. That was specifically spelled out in the motion.
Then why wouldn't that go to the weight that they would give it rather than to the admissibility of it?
Your Honor, the law, I think, is very clear that a predicate must be established. And when I say the law, the Supreme Court of Florida has said that a predicate must be established before it's admissible. Just like when it's not properly refrigerated, it's inadmissible. It's not a matter of weight for the jury. It's not admissible. When it's not drawn by the proper personnel, it's not a matter of weight. It's not admissible. And when the procedures are not followed, it's not a matter of weight. It's inadmissible. And just like a trial lawyer has the obligation to make a specific objection, a trial judge has the obligation to a court of appeals to make an order, a ruling, and a finding of fact, conclusions of law, that an appellate court can review. And otherwise, we can hide under the tipsy coachman doctrine and wouldn't need a court of appeals. And so clearly we submit that the trial judge failed in his obligation in making these findings of facts and conclusions of law, and the state failed in their burden of proving this evidence was scientifically reliable.
What if the state witness comes in and says to the judge and the jury that we followed the standard procedures and everything was done in accordance with the manuals and the other publications that tell us how to deal with these things? Then doesn't that shift the burden to you then to show that that's not the case, that the vials weren't inverted?
Yes, sir. I think if that had happened, but here it was a stipulation accepted by the judge, stipulated by the parties. They didn't even trigger the statutory presumption that the jury should be instructed on the probable correctness of the test.
But wasn't there testimony in the record, though, that I can't remember which police officer said that they followed the normal procedures for the testing of this blood? It was a kind of a generic description of it, but it was...
Yes, sir, but that's what we were saying. All those issues were contested, or at least the refrigeration was contested, and the records in furtherance of that, and whether it was shaken and treated properly.
Have you got any case that says that you've got 9 things that you've got to establish before that comes in, and the vial was inverted, that the coagulants were put in there, whatever, go down a litany of things that must be done, and the state has to demonstrate each one of those, or can the state just simply say we follow the procedures?
I think that's what this case is largely about, Your Honor, is something on the right line.
Yeah.
Let me ask the question. If we're going to use not the administrative law to introduce
I'm sorry, Your Honor.
If we're not going to use the administrative rulings to introduce the blood, isn't there evidence to show that the chemist who tested the blood said it was filtered and screened, there was nothing unusual? You have the police officers testifying that it was removed from the scene to the Ocala Police Department, refrigerated, sent to Jacksonville, refrigerated, sent to Orlando, refrigerated, and all that happened within a short period of time. And then there's other scientific evidence that if your theory is correct, the test would not have been as accurate, but the test results would have been minimally changed. Isn't that the testimony in the record?
There is that testimony in the record.
Doesn't that meet the common law test that you are asking us to apply?
I'm asking you to tell the trial judge to do this in the first instance instead of saying it's a fact question and leaving it for the jury, which is what happened in this case.
Well, but to argue the other side of that coin, if we were to accept your theory, if the court listens to a proffer from the relevant witnesses and is satisfied that the evidence is in fact reliable, are you then suggesting that the defense wouldn't have the opportunity to challenge that evidence and say, well, we think it's not reliable, or, well, let's put it this way, you wouldn't be able to come before the jury and then question the state's testing methods, their conclusions, all that? Now, I guess I'm just having a hard time because it seems to me it's got to work both ways. If the trial judge says this evidence is reliable, then the number's the number, and it goes in, and you really shouldn't have a chance to ask them anything about it. On the other hand, if the trial judge says it's admissible, now you guys go squabble about the weight to be given to it, then both sides get to take an equal shot.
Your Honor, under your first scenario, the state gets the benefit of the strict liability theory. Under the second scenario, the state doesn't get the benefit of the strict liability theory. And you're right, it's up for grabs in the sense that both sides get to challenge the evidence. Here,
But even if the state had the benefit of the strict liability theory, you know, they introduced a blood test and it's higher than .08. Don't you think, even though the judge has made the prerequisite ruling of reliability, and or actually more accurately admissibility, that the judge has made that ruling, that the defense still has the opportunity to come in and question the methods, the collection processes, all the things that may have happened to the blood in the interim in an effort to cast doubt on the reliability of the test?
If the record were clear, I would agree with you, Your Honor. The record is not clear in that respect, and it is clear that the state argued that it's a matter of weight for the jury, and the judge just simply said, your objection's overruled.
Okay, you've got 5 minutes left if you want to reserve, sir.
I'll just go ahead and reserve. Thank you.
Good morning, Your Honors. May it please the Court. My name is Carmen Corrente from the Attorney General's Office representing the state. I would like to start out by reminding the Court that this objection to the blood was made at trial. It was based upon the administrative rules only. No other motion was made, and it was made at the hearing, which required the Court to hold, if it were to do such a reliability hearing, would require it to hold a lengthy hearing and have the witnesses come forward. This, at trial level, the judge heard argument and determined that from the evidence that he was given at that time, that it would be reliable, and I think he would have revisited that at any point if the state didn't cover it completely during all of its testimony.
What specific finding did the Court make? I haven't read the entire transcript, but Mr. Harper has indicated to us that the judge said your objection to the admission of the evidence is overruled and didn't make any specific finding. Is that correct?
Didn't make any specific factual finding as to reliability. His finding was that it was admissible, and then any of his arguments went to the weight of the evidence.
So your contention is that in making the determination of admissibility, inherent in that is a finding of reliability?
Yes, that would be my contention in this case.
So tell me, where in the record do we find support for the 3 factors laid out in the test for admission under the common law?
Well, we have, first of all, a gas chromatograph was used, which is a reliable. There are
no problems with that. I think the real issue is, from the point of collection up to the point of examination. I don't think anybody's seriously squabbling about the instrument
Right, okay.
or the qualifications of the person
The
who,
person and
who
all of
operated it.
that.
I think the squabble is, was it collected properly and was it maintained and handled properly up to the point of the examination? So tell me where in the record I find the competent evidence to support the three-pronged test that you've got to satisfy.
The competent evidence comes from the state's expert, the FDLE analyst, who analyzed the blood. And I can go get specific pages.
Well, just summarize it for me.
Well, what she testified to was that you have to worry about the coagulant. You have to worry about whether or not there was any clotting, because that will give an artificially high reading to some parts of the blood. But she says that she goes ahead and tests it anyway, even if there is evidence of clotting, and that the result is affected only to a certain percentage. However, she found no clotting. She rolled the tube in her hand. She screened it, as one other judge mentioned. She screened it, she filtered it, and made sure she saw no clots. So that as far as the mixing of the coagulant. And don't forget, the anticoagulant is in the bottom of the test tube, which the blood will rush into as it is filled. The testimony is also unclear as to whether or not that was shaken or not, but if it was transported to Jacksonville and back and to Orlando, you would think that it was shaken, that the blood sample would have been shaken and would have been in contact with the bottom of the tube.
So you're essentially saying that the predicate is established by, we should take judicial notice of the way UPS or post office handles parcels,
Well,
or the compliance with the state's requirement on scientific evidence?
no, Your Honor, I'm adding that to the fact that the FDLE analyst who analyzed the blood, the defense expert didn't analyze that blood. The blood was only analyzed by the FDLE. She testified, and she testified as to what she saw. There was no clotting, and she filtered and screened it to be sure of that as best as possible. There was also a second vial of blood that she could have gone to and she explained her procedure. If she sees clotting, she still tests, and then she would go to the second vial. That didn't happen. So I think that is enough there. But we have the additional evidence that the anticoagulant's in the bottom of the tube, that it was transported several places in the trunk of vehicles, and that you would have to think that it would have had to mix. That the motion is not something the administrative rule requires. The administrative rules that to be thoroughly mixed with the anticoagulant, and that is what she testified to as far as that. She testified that it was well mixed, that there was no clotting.
What about the preservative?
Well, the preservative, I believe that her testimony also covered whether or not there was bacteria in the blood. She actually said it would benefit the defendant, and that's where some of that conflict testimony comes in. But because any bacteria in the blood would actually consume some of the alcohol in that blood, and it would lower the result. But either way, she testified as to the effect on the actual blood sample is going to be 10 to 20%. And that kind of difference would still put him well over 0.08. And this is just one factor. Because we don't have the presumption, then we have that the blood was admissible evidence and certainly tended to be relevant and to prove that he was over 0.08. And I think even with all of the problems, this court can look at the testimony that was subsequently introduced and find that it was all covered. And all of the testimony by the FDLE analyst supports the fact of the blood alcohol level, and that the blood reading was at least admissible. And you can argue as to the weight. We also have the defendant's own testimony that he had been at a party, he had been drinking, everyone in the truck had been drinking. So there's no question that there was alcohol in the blood. The question is how much, and whether or not this blood alcohol test is a reliable indicator of that. And the fact that had any of defendant's claims been true, the effect would have been minimal, and that's in evidence, I believe is enough to sustain the admission of the blood as evidence to be considered overall. If there are no other questions, I would rely on my brief for the remainder of the argument. Thank you.
Sir, you cite the Rafferty case?
Sir?
You cite the Rafferty case?
Yes, sir.
In reading through that case, the court paid attention to the factual occurrences and what the judge heard during the case. You're arguing that the administrative rule was not complied with, but I've not heard anything that said that the sample was adversely affected. We have the testimony of the expert from FDLE. We have the examination that she did visually, the screening she did scientifically, and we have the timeline about the refrigeration versus the time of not being refrigerated. You had an expert. Is there something in the record that shows that with those facts, the sample was contaminated or not sufficiently preserved for a valid scientific examination?
Your Honor, as I stand here, I can't just pull a page and say yes or here it is. But as I recall from the expert's testimony, there was the defense expert testimony.
Right.
There was some dispute along those lines. But what I wanted to respond to, if I may, with the state's argument here, is that under Rafferty, if it's not properly handled, refrigerated, it's not admissible. And it's not admissible because the blood keeps fermenting. And I'm not an expert, but fermenting sounds like it makes alcohol.
But that's not what the record...
I understand that, and this is not a refrigeration issue, but the preservative issue is. And so back to the shaking and the mixing of the preservative in a timely and proper fashion, the rules of administrative procedure say you shake it after you take it out. And while there may be no evidence of clotting, it's certainly, as the state says, unclear whether it was shaking or whether it was mixed preservative and anticoagulant. And we still say this is the state's burden. And just like in Leverett, this case is trying on dual theories of Duval and normal faculties impaired. And so what the state is doing here is getting the benefit of both. And it could have been a 3-3 jury on each of those theories. And we have no findings of fact to protect a defendant from the jury having been, in effect, contaminated by improper evidence and how it's applied.
Well, your argument all hinges on the sample being less than pristine. And what troubles me is that there was another sample vial available for testing, which was not. So what we have is hypotheticals and theories on one side, and then we have Sandra James testifying that she examined it, she screened it, she looked at it, and felt comfortable enough that it was okay that she didn't test the second vial, which was available to be retested to show that there was a difference between the two or that it was not preserved properly.
Yes.
So all of the evidence, scientific evidence, a fry test, if you will, to show that it was okay.
Well, I still rely on Everett in terms of it being disputed. While there may be enough to satisfy one argument, I would submit it's not sufficient to satisfy the state's obligation to prove the scientific reliability.
Yes, Counsel, Judge Orthinger had one last question.
Mr. Harper, your second point on appeal is that the trial court erred in jury instructions by instructing on the presumption.
He didn't.
I don't find that
He
anywhere.
didn't. And I found y'all's case in Richardson v. State, which is the entire panel variously participated in. I think you were the trial judge in that case. So that wasn't a good argument, Your Honor.
Was the argument withdrawn in your reply brief?
No, sir.
My
I relied
understanding
on
is
it
that
because there's Robertson is in there, and I felt like Robertson is important for consideration of the issue that we still are trying to make. And
I guess I got to tell you, I'm troubled by the fact that, an issue is asserted that has no factual basis. And when it's pointed out in the answer brief, it's not withdrawn in the reply brief.
And I would withdraw it if that'd be appropriate, Your Honor, because my work product, not anybody else's, and it was not my best effort. Thank you.
Thank you, counsel. Your time's expired.